So, as I say, welcome to today's session on this employment law update in our People Matter series. Just a few housekeeping rules first of all. So the webinar is being recorded and the copy is going to be available afterwards. You'll all be sent a copy of the slides. If you've got any questions, please put them into the Q&A and we'll try and deal with as many of them as possible at the end of the presentation. And please do give us feedback at the end of the session, which is always incredibly helpful. So I said a moment ago, this People Matter webinar, it's an employment law update. It's designed to bring you up to speed with a range of current themes and developments in employment law. The aim really is to kind of put those issues into your consciousness. So if you have to deal with something that's related to these topics within the next few weeks and months, you'll think to yourself, I remember that Mills Reeve raised this issue, and you'll recall that there's been a development in that area which you need to bear in mind. And so with that aim in mind, we're covering a range of topics today, and I'll put them on the slide there. So flexible and atypical working, holiday pay, the clash of rights under the Equality Act, the menopause. We'll look at some of the latest ET statistics, and then we'll look at some legislation that's coming down the track. So Danni is going to start us off with atypical and flexible working. Over to you, Danni.
Thanks, Stuart. So the last few decades have seen a huge increase in the number of people whose working arrangements are atypical. So what we're talking about there is someone other than an employee who's working for one employer full-time under a contract of employment. The gig economy is one of the most high-profile employment law issues of recent times, and there have been a series of high-profile cases, particularly relating to couriers and taxi drivers, that have been backed by the unions. So the lack of protection for atypical workers was particularly clear in the context of the pandemic. And so there's been a general push for more stable contracts and enhanced rights, with several inquiries and reviews into how to combat this one-sided flexibility in the gig economy. So that's 0 hours contracts and casual workers who remain on insecure contracts, often for long periods of time. So all of this has led to the Workers' Predictable Terms and Conditions Act 2023. So this act received royal assent on the 18th of September this year. And the government said it will come into force around 1 year after the date of royal assent. And that's to ensure that employers have time to prepare for the changes. So what are these changes then? So the Act gives workers the right to request a more predictable working pattern. So those employees with patterns that lack certainty of hours, times, days can request to work certain fixed hours or days, for example. The Act applies to all workers and employees, so notably that includes agency staff. Where a worker is on a fixed term contract of less than 12 months, a worker now may request that the term is extended so that the contract is longer than 12 months or even that it becomes permanent. The qualifying period for this right hasn't actually been confirmed yet, but we think it's likely to be 26 weeks employment, but that 26 weeks doesn't have to be continuous. This will be set out in the regulations in due course. Another thing to note is that individuals will be able to make 2 requests per year. So you might be familiar with the flexible working regime where it's 1 request per year, and this is going to be 2 requests a year. And employers must deal with the requests in a reasonable manner and communicate decisions within 1 month. So it is quite a quick turnaround time. There will still be potential grounds for rejection though, and these are set out on the next slide. And they mirror those for the statutory flexible working regime. So you can see there the sort of broad heads of additional costs, inability to meet customer demands, recruitment of staff, detrimental impact on the employer's business, etc. So in terms of the likely impact on employers in practice then, it's important to remember it's a right to request, not to have. So you can still reject the request on one of those grounds set out on the slide. In terms of compensation, it's likely to be limited to a maximum of a number of set weeks, and that's going to be set out in the regulation. But if it's going to mirror the compensation that we have under the flexible working regime, it's likely to be 8 weeks pay. So we think that this act could act as a catalyst for significant changes, and it also shows an increased focus on how to manage casual workers. And just last week, ACAS published a draft code of practice, which it's currently consulting on, which will sit alongside this new act and provide guidance on how to handle requests for a more predictable pattern. So the code won't be legally binding, but it will be taken into account by an employment tribunal when considering relevant cases. The consultation is still open and it remains open until mid-January. But things to start thinking about now then. So think about potentially which workers and which parts of your organisation might be affected. For example, the higher education sector and other industries that rely quite heavily on fixed term contracts may need to pay particular attention to this new change. Think about in advance what requests could be accommodated and how you're going to potentially implement those. And if not, why not? And think about those reasons that were set out on the previous slide. I'll pass over to Stuart to talk about flexible working.
Thanks, Danni. The second piece of legislation that's recently been passed is the Flexible Working Act 2023. We also expect this to come into force in the second half of 2024. And this act, as the name suggests, makes changes to the statutory right to request flexible working. But as we know, at the moment, the existing right extends to all employees with 26 weeks continuous service. Employees can make one request a year, and employers are under duty to consider requests reasonably and to notify employees of a final decision within a 3-month decision period. So the new act makes 4 key changes, which I've set out on the slide. So first of all, employees are going to be able to make 2 statutory requests in any 12-month period instead of 1. The waiting time for decisions to be made will be reduced from 3 months to 2 months. And employers won't be able to refuse an application unless the employee has been consulted about it. And the new act removes the existing requirement that the employee must explain what effect the change applied for would have on the employer and how the effect might be dealt with. What the act doesn't do is implement the government's long-standing promise to make the right to request flexible working a so-called day one right by removing the 26-week qualifying period. That, of course, would probably be the most significant change of all. But that said, the government's repeatedly reiterated its intention to change that. So we do expect that to happen via secondary legislation. There still remains some areas of uncertainty. In particular, so far, it's not been made clear what consultation will mean and involve, or whether employers should allow employees a right to appeal if they refuse a request. So we expect those 2 issues to be clarified either in the regulations that need to be made to bring the Act into force, or in the ACAS code that's being updated to reflect the new law. And so in that respect, you might remember that ACAS has consulted on how to update its code and guidance to reflect the shift in flexible working practices since it was last published in 2014. And ACAS is currently reviewing its responses. So some practical tips for you to consider in the interim, which I've set out on the slide there. Well, obviously, review and update your policy ready for 2024. Ensure that you've got a system in place to deal with more requests and more quickly. Consider what consultation might look like, or keep an eye on the law in relation to consultation. Do look out for the new ACAS code and guidance. And as always, fairness and consistency when dealing with flexible working requests is going to continue to be key. Over to Danni now to talk about holiday pay.
Thanks, Stuart. So looking at holiday pay and some recent developments then, we've had some important questions about statutory holiday entitlement answered by the Supreme Court in recent years. So you might recall in 2021, the court looked at the question of who is entitled to holiday pay. And that was the Uber case, where the court said that you have to satisfy the legal definition of a worker in the working time regulations. And the Uber drivers did that, so they were entitled to be paid holiday. And the court was not satisfied by the employer's arguments that they were self-employed. And then in 2022, the Supreme Court looked at how holiday pay should be calculated, where a worker was not doing predictable hours. So many of you will recall the case in Brazil and the facts of this one, which involved an hourly paid music teacher who only worked during term time. And in that case, the court said that each week of holiday pay should be calculated by taking the average weekly pay over a reference period, which is now 52 weeks. So that case did make it a lot more complicated to work out holiday pay. And then more recently in 2023, it's brought us another big holiday pay case with the decision of the Supreme Court in Agnew. So this case involved police officers in Northern Ireland. So there were a number of issues that were just specific to Northern Ireland. However, the key issue for the whole of the UK was how this legislation allows workers to bring claims for underpaid holiday pay, and that's based on a series of deductions and how that should be interpreted. So under that rule, rather than having to bring a separate claim within 3 months of each underpayment, a worker can link a sequence of underpayments together and bring a single claim within 3 months of the last underpayment in that series. So in 2015 in Bear, Scotland, the Employment Appeal Tribunal said that a series would be broken by a gap of 3 months or more between successive underpayments. But that decision had been queried in a number of cases since, and we've had to wait until now to get the final answer. So the Supreme Court in Agnew said that a break of 3 months or more does not break the chain. Instead, whether underpayments form a series will be for the ET to decide based on various factors. So this will potentially make it easier now for workers to make historic claims where they've not been paid holiday pay correctly. In Great Britain, the law was changed so that you could only go back and recover underpaid holiday pay and other wages for 2 years, known as the 2-year backstop. So the financial impact of this ruling will be less significant in employers that don't operate in Northern Ireland, when in Northern Ireland they don't have that backstop. The police officers in Agnew can probably now claim back to the start of their employment, meaning the final bill could be more than £30 million. So we're not expecting the number of claims to be that big, mostly because employers have changed their holiday pay calculations to reflect the case law over a number of years. And also many claims are now likely going to be out of time. So important though these decisions are, they don't necessarily mean the law on holiday pay has settled down. And that's because the government is consulting on further changes, some of which now take advantage of the post-Brexit freedom to modify EU-derived law. So the government has opened 2 consultations aimed at removing unnecessary complexity when it comes to holiday pay. So the first consultation is effectively looking to reverse the decision in Harper and Brazil and the sort of 12.0% calculation we used to use. So that will be an interesting one. And then the second consultation is going to be looking at merging the 4 weeks basic holiday that's derived from EU law and the 1.6 weeks additional holiday, to which currently different rules apply. So the government is proposing creating a single holiday entitlement of 5.6 weeks and clarifying the minimum rate of pay and what will count as normal remuneration. So that will be really handy, that consultation, I think. They're also looking at allowing rolled up holiday pay for those with the regular hours worked. So you might recall a number of years ago, rolled up holiday pay was no longer allowed. So potentially that could be coming back in. And then they're also looking at removing any legal requirement for businesses to keep a record of daily working hours, so hopefully reducing some admin burden. However, in reality, employers are still likely going to have to keep records for example, national minimum wage purposes. So whether that one's going to have much of an effect, I'm not too sure. Thank you, Stuart.
Thanks, Danny. Turning next to what we've termed the clash of rights. And what we mean by that are the continuing case law developments where employment tribunals have had to grapple with what are essentially competing protected characteristics and beliefs under the Equality Act. So last year, you might recall that we saw a number of cases on gender critical beliefs, and most notably the Forstater case. And what those cases said is that those types of belief can, in principle, qualify for protection under the Equality Act. And what we're seeing now are cases where the rights of those holding religious or gender critical beliefs are having to be balanced against the rights of others. And we're being given a bit more guidance on the legal obligations on employers to protect both groups from potential discrimination in those circumstances. I've mentioned 3 recent cases on the slide there, and what we have in common, or what they have in common, is that we continue to see employment tribunals drawing a distinction between the belief itself, so between the protected belief, and the way in which that belief is manifested, i.e. the manner of the employee's actions and the employee's conduct in respect of their belief. So, for example, the school chaplain in the Randall case, the employment tribunal said, had crossed the line. He delivered a sermon in the school chapel on the conflict of values, and he'd stated during that sermon that pupils didn't have to accept the ideas and ideologies of LGBT activists where they conflict with Christian values, and that the students should make up their own minds. And that sermon led to numerous complaints by staff and students, and the chaplain was disciplined. And what the employment tribunal said was that the employer's actions in disciplining the chaplain didn't amount to religious discrimination, that the treatment of the chaplain wasn't because of his beliefs, but because of his objectionable manifestation of those beliefs. And in particular, Mr. Randall had ignored previous advice to deal with sensitive topics in the classroom where they could be discussed. And by addressing them in a sermon, he risked distress and harm to LGBT plus students, and the school had therefore been justified in objecting to the way that Mr. Randall had manifested his beliefs. In the case of Farmy versus the Arts Council, Miss Farmy had brought a claim for harassment when emails and petitions were sent round, some of which referred to gender critical beliefs in a negative way. Miss Farmy brought an employment tribunal claim and won, with the employment tribunal agreeing with her that the way the comments had been made amounted to harassment. So again, an objectionable kind of manifestation of the belief. And then finally, and perhaps most importantly, in that case of Higgs that's on the slide, this is an employment appeal tribunal case, and that looked at the case of an employee who'd been dismissed from a school because of Facebook posts which she'd issued based on her Christian beliefs. And those Facebook posts had criticised education on issues such as same-sex relationships and trans rights. Now, in that case, the EAT said that the tribunal had taken the wrong approach, and they sent the case back to the employment tribunal, but with some guidance which is quite important and quite helpful. So the first part of that guidance were kind of 5 basic principles. And what the Employment Appeal Tribunal said was that these 5 basic principles should underpin the approach that tribunals should adopt when assessing issues of kind of balancing rights of religion and belief and freedom of expression. So what were the 5 principles? Well, the first one is that employment tribunals should take account of the importance of the rights that are being considered. The freedom to manifest belief and to express views relating to that belief are essential rights in any democracy, and that's whether or not the belief in question is popular or mainstream, and even if its expression may offend. So take into account the importance of freedom of expression, but then also take into account that that right to freedom of expression can be qualified, and that the manifestation of belief in free expression will be protected but not whether law permits the limitation or restriction of such a manifestation or expression to the extent that it's necessary for the protection of the rights and freedoms of others. And then whether a limitation or a restriction is objectively justified is then always going to be context specific, and different considerations are always going to arise depending on the nature of the employment in question. So it's always necessary to consider issues of proportionality in terms of those limitations or restrictions. And then the Employment Appeal Tribunal gave us a kind of helpful list of considerations that should be taken into account when you're looking at that issue of proportionality. So first of all, the content of the manifestation, what's actually being said, the tone that's used, the extent of the manifestation, the worker's understanding of the likely audience, the extent and the nature of the intrusion on the rights of others, and any consequential impact on the employer's ability to run its business. Whether in expressing their view, the worker has made clear that the views expressed are personal, or whether they might be seen as representing the views of the employer, and whether that might present a reputational risk. Is there a potential power imbalance given the nature of the worker's position or role, and that of the rights of those whose rights have been intruded on? What's the nature of the employer's business? In particular, is there a potential impact on vulnerable service users or clients? And then finally, whether the limitation or restriction that's being imposed is the least intrusive measure open to the employer. So what these factors point to is that the more combative the tone and the wider audience for the remarks being made, the more likely it is going to be justifiable to restrict what's being said. And in addition, it's going to be easier to justify imposing restrictions on the tone and frequency of posts rather than, for instance, imposing an outright ban. So practically speaking, where does that leave you, and what kind of tips do we have for you? Well, I think the first one is the importance of policies. Employers can use their policies to set out their values and acceptable behaviours, both in the workplace and in social media. And if you look at the previous cases, case of Macareth, for example, the employer in that case won, and that they had a clear policy on how transgender service users should be treated and could show why the policy had been adopted. In Forstater, the employer lost, didn't have a policy about what staff could and couldn't say, and actually encouraged lively debate about non-work issues. It's best for employers to remain neutral, focusing on sensitively trying to balance competing rights and ensuring that opposing views are treated consistently. Clearly, policies have to be proportionate. They need to be applied equally and consistently to all protected groups. It's as important as ever to ensure that managers understand them and to train staff to respect each other's beliefs and opinions and promote diversity. And as we've seen, this topic is a complex one. It's a fast-moving one. So if you are considering taking any action against an employee for expressing their belief, we suggest you consider taking legal advice, particularly to help you with that question: is it proportionate, or could something less intrusive be done? So a difficult and complex topic. Danni is now going to look at continuing developments around menopause in the workplace.
Yes, so October has been Menopause Awareness Month, and the awareness of the effects of the menopause in the workplace continues to grow. Menopause remains on the government's agenda, and a menopause employment champion was appointed earlier this year, a lady called Helen Tomlinson. And she's done a policy paper that was published on the 18th of October to coincide with World Menopause Day, with a summary of the work that she's carried out so far. So there's a 4-point plan which will be implemented sector by sector, with hospitality, retail, care, manufacturing, and professional and technical sectors first. A portal has been created, which includes a repository of menopause resources and guidance for both employers and employees. And then on the 1st of June 2023, the British Standards Institution published a detailed guide, which is worth taking a look at if you've got some time. So whilst there's no menopause-specific employment laws and menopause is not a standalone protected characteristic, depending on facts, there may still be a risk of discrimination related to age, sex, gender reassignment, or disability. And in terms of disability, a common menopausal symptom may meet the definition of a disability. And there have been several ET cases where the effect of menopausal symptoms have been held to be substantial. But even if the symptoms don't quite meet the definition and it's not deemed to be a disability, it is still important to provide support to those individuals. So looking at how menopause can affect performance, last month we had a first instance tribunal decision in a case involving a lady called Mrs. Linsky, who was a telesales consultant. Menopause symptoms affected her performance, and her employer did take many steps to try and assist her, but more steps were required. The claimant succeeded in her reasonable adjustments claim, and the ET said that giving her a low appraisal rating, a written warning, and removing all of her sick pay amounted to discrimination arising from disability. The employer was requiring her to meet standards of performance which she couldn't possibly meet due to her disability. And the compensation in this case was fairly sizable. It was almost £65,000. So it does point out the importance of this condition and how the tribunals are taking it. So in terms of action points for employers then, some practical tips, managing proactively and positively. Performance, attendance, or sickness absence issues may be related to the menopause, so it's important to try and identify the root cause of the issue and consider whether menopausal symptoms could be having an effect. It's important to seek medical advice if any issues arise, so getting OH referrals and reports back are really helpful, and making sure that you take health issues fully into account before any formal process is commenced. And many workplaces do have them already, but if you don't, consider drafting a menopause policy and referring to it at the initial outset of any possible issues. So I'll pass over to Stuart to look at some ET statistics over the years.
Thanks, Danny. Well, it wouldn't be an end of year kind of employment law update without a look at the latest ET statistics, which have been published for 2022 to 2023. And surprisingly, given that it's Halloween, it isn't all scary news for employers. I think three interesting points stand out. So first of all, the number of claims from individual employees and workers have actually gone down. And they've gone down to the levels that we saw before the pandemic, and in fact, to the years when tribunal fees were in place. So the total number of claims made in the 2022-2023 reporting period was 85,301. And in comparison, in 2020 to 2021, the figure was 117,926. Should say we're still awaiting the figure for 2021 to 2022 as that's being verified. The second point I wanted to make then, that this is quite scary actually if the award was being made against you. The highest award of compensation made in the 2022-2023 reporting period was an award of £1,767,869, and that was made in a disability discrimination case. But what about the kind of average and median awards in other types of claim? Well, they're all actually down. So disability discrimination is the only type of claim where the average and median awards are up. In the other types of cases, the level of awards is down. I did just want to say a quick few words about cost awards as well. So cost awards still remain relatively rare in the employment tribunal. There are actually 195 cost awards that were made in 2022 to 2023. 150 of those were in favour of respondents, so in favour of employers. And interestingly, the maximum or the highest of those cost awards was an award of 174,000 to one employer. And then a final point to note in relation to employment tribunals, do be aware that from August 2023, there was a new ET1 claim form published, as well as a new ET3 response form. So you do need to make sure that you're using the up-to-date forms. And then finally, in terms of the presentation, before we look at some questions, just a very quick update with kind of a legislation tracker and what's coming down the tracks. So all of those laws that I've set out on the slide there have been passed by Parliament and have received royal assent, with the exception of the bill on harassment. You might know that that bill's been somewhat controversial and it's still going through Parliament currently. But so although those bills have largely received royal assent, none of them are yet in force yet, and the reason for that is secondary legislation is needed in the form of regulations to set out full details and the exact dates when they will come into force. And most of those regulations aren't published yet. But what we can say is that at some point during 2024, we expect to see come into force protection or enhanced protection against redundancy during pregnancy, and then a new right to 1 week's unpaid leave to provide care for a dependent with a long-term care need. 1 year after it's passed, we'll see the new duty on employers to take reasonable steps to prevent sexual harassment, and that's going to be supported by an EHRC statutory code of practice. And then around April 2025, we should see a new right for parents of premature or sick babies to 1 week's paid leave for each week that their baby's in neonatal care. And finally, minimum levels of service are going to be set for specified public services, which are going to need to be adhered to when there are strikes. And there was an announcement that you may have seen recently that those minimum levels of service are going to extend to schools and colleges. A lot of that legislation, with the exception of the minimum service levels for strikes, has cross-party support. So notwithstanding the outcome of the general election when it comes, we're likely to see most of that legislation come into force. So going to turn now to some of the questions that you've been submitting into the chat. Just while I've been speaking, I think, Danni, you've had the opportunity to have a look at some of those, and you're going to answer one or two.
Yeah, so I'll start with the ones that relate to the atypical working regulations, where the first few questions came in. So we've had a question with regards to bank workers in NHS and whether they'd be covered by the new regulations. So the short answer is yes, it's employees and workers, and that includes agency staff. I'm not aware of any carve out for the NHS at the moment. We've had another question with regards to predictable working and how it will affect fixed term contracts for those on maternity leave cover. So the question is, will it be reasonable for a refusal to extend, for example, if they're just covering mat leave? So yes, it will apply to them, but the grounds that were set out on the slide, I don't know if we can go back to them, but you'll get the slides later. The potential grounds for refusal are set out there. So it would be a case of relying on one of those grounds, for example, planned changes, insufficiency of work, impact on business inability to meet customer demand, etc. So also with the maternity cover, depending on the length of it, we're not too sure yet what the qualifying period is going to be to be able to make these requests. But for example, if it is going to be 26 weeks, that individual who's covering the mat leave will not necessarily be in a post long enough to make the request. Stuart, I don't know if there are any other questions at the start that you wanted to cover.
Yeah, there's a couple of questions about the 2-month decision period that I referred to in relation to the new flexible working action. And the question here would you advise we deal with any flexible working appeals within the 2-month response time frame, or is the time frame usually just for a decision, with there being a further time period for appeal? The answer to that is it remains to be seen, because none of the legislation so far specifically addresses the issue of an appeal. Based on what we've seen, that 2-month decision time frame would be for the original decision, would encompass an appeal. That said, it's always best practice to try and make decisions with respect to those matters as soon as you can. Do you want to pick some of the questions up around holiday pay?
Yeah, okay. So we've had one question in with regards to the 2-year backstop. So yes, so that's applicable in Great Britain. So claims for a series of deductions of wages or unpaid wages in relation to the holiday goes back for the 2 years, but it's different in Northern Ireland. There's a question with regards to including annual bonus or half-yearly commissions. Should they be included for the purposes of calculating average holiday pay? That's a good question, and sort of the area is very complicated, but the short answer is, if it forms part of regularly paid and its normal remuneration, then it quite possibly could be. So for example, if you've got regularly paid overtime, guaranteed overtime, that will be included. And that's where it's quite a tricky area when you're looking at what calculations you should be doing for the 5.6 weeks and any sort of enhanced contractual rights and the 4 weeks that relate to the working time directive. Don't know, Stuart, if you've got any other thoughts on some of the holiday pay questions, but the two that popped out under the 2 themes.
Well, I suppose what we're seeing, this might be the kind of beginning of the kind of tangible change to some of the employment law legislation in the UK following Brexit. So these kind of things are a departure from the position under the working time regulations designed so the government says to make it kind of easier for employers. So that is kind of stripping it back to much more basic levels, and I think that's the direction of travel. Couple of questions for me. Can you share which disability discrimination case warranted the highest payout? No, but we'll try and find out and send it when we send the slides. That was just in the statistics. There's a question: was it paid leave or unpaid leave for the new right for caring for a dependent with a long-term care need? And the answer to that, it was unpaid leave. There's a question there: do you think employers could be forced to bring back dispute resolution prior to taking disciplinary action against workers? No suggestion of that on the horizon at the present time, so far as I'm aware. And then a couple of questions around the issue of consultation in the context of the new Flexible Working Act. So one, who should employers consult, the staff, the union, or both? I mean, as the Act's drawn up, it's a kind of going to be a requirement to consult with the member of staff, not with the union. The only caveat to that would see if you had any kind of flexible working policy that required you to do something differently, but under the Act itself, it would be to consult with the member of staff. And then an interesting kind of question related to that is how would that consultation take place in circumstances where the employee is no longer required to say what they think the effect of the proposed flexible working change will be on the employer? Which is an interesting point, and we'll have to see what the detail is in relation to how consultation should take place under the regulations. I think that's why it's important to look out for that new ACAS code, as well as looking out for details of when the regulations themselves are published.
There's a question that says, can you recommend a really clear setting out of how to do the maths for calculating holiday pay as per Harper and Brazil? there is quite a useful government calculator now on the government website where you can work out the statutory holiday entitlement for those with irregular hours. So annual hours contract, shift workers and part-year workers. So I would really recommend looking at that. It's got a sort of step-by-step, you input the various figures and it generates a number for you. So sort of a quick answer, and that's a good first port of call in relation to your statutory holiday entitlement. Any other questions that I can see we haven't covered? So I don't know if there's any others you wanted to pick out. There's quite a few that sort of similar that we've covered.
There's a question now about the new rehabilitation of offenders legislation. I think that's going to be covered in one of our kind of written updates, so look out for that.
There's a question about predictable working and supply teachers. So the nature of supply work is in itself ad hoc and short notice. So what's going to be happening with that? So in terms of predictable working and the request, an individual is still going to be able to make a request, but you will be able to have a rejection reason, as we talked about earlier. So for example, a key one with ad hoc supply teacher would be there's just an insufficiency of work for the period of time that they propose. So there are enough sort of headings for you guys to cover the rejections for that. It's a right, but it's not a right to request, but not to have. I don't think I can see any more questions on my side.
There's a question there about do minimum service levels for industrial action apply to universities as well? So I need to check that. We can confirm that. What I'd seen was schools and colleges, but I'll have a look at that and confirm.
It says one of the questions, it's back to holiday pay, is it's a difficult topic, so understandable. So this question says, in relation to leave such as carers, if an employee is part-time, will the 5 days leave be prorated, or will they still be entitled to the full 5 days per year? So it is prorated, but as was the case in Harper and Brazil, if you've got someone who works irregular hours or it's sort of term time only, you're taking the holiday from the 52-week period before that they've worked. So if you've got any periods of that haven't been worked, you'll go for the next 52 weeks worth of working time. So hopefully that one helps answer that question.
I think
I don't think we have the new rate. Sorry, I was just saying there's a question about national minimum wage, but I don't believe they've been confirmed yet for 2024.
And I think someone said, will the slides be shared? Yes, the slides will be shared. So do look out for those. I think that brings us to the end of this morning's webinar. Thank you very much for attending. As I said at the beginning, when the webinar ends, you'll be sent a link to give some feedback, which would be much appreciated. So thank you again for attending and have a good rest of the day. Thank you very much. Cheers.